Question, can the district attorney be sanctioned for her behavior? Yes, she can be sanctioned by the Florida bar. We are all under the Florida bar. If they find that she violated some ethics rules, then it is a potential sanction that could happen. I'm not saying it will happen. It's just possible. Sweet Tea, is she letting her emotions get the best of her? Is this the L you were talking about? Yes. When you lose a ruling and the judge tells you not to do something, you have to take that L and you've got to move on. She refused to do it.
Yes, ma'am.
With regards to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. The impeachment, where it's
so listen, again, this is what she says that she said. She's saying, I did not say the defense. Listen.
with regards to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context that was not intended in any way, shape, or form.
And you can tell the attorney over here wanted to get up and say something because she is absolutely wrong. But the lead defense attorney said, chill. That's why we have a record. That's why we have a record. And guess what else? We don't just have a record. We've got a camera right there that's filming all of this and recording all of this. And it is very easy. It is very easy to go back and listen to this.
Roll that beautiful bean footage.
You were told to quit your job and the defense would take care of us.
Of the judge.
No.
Excuse me.
The defense? No.
Much comes out.
And we have another motion.
Why the fuck you lying? Why you always lying?
The judge does not rule on the motion for mistrial. He takes it under advisement. Somebody asked, would you be surprised if he granted it? Yes, I would be surprised, just because I think it would mean he's going free. And I think the judge would rather it be taken up on appeal than grant a mistrial for this on a double murder. Let's listen to some of the defense argument of why he thinks this should be a mistrial.
Of that contention, there was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state is essentially trying to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, but you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Dennis has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate, it is highly prejudicial. This jury has been tainted, and we move for a mistrial.
Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness. And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table. And despite the judge, Your Honor's instruction to ignore it, it's pretty hard to ignore something like that when their entire questioning for the last 30, 40 minutes have been so improper, and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
His cross-examination here.
Did you ask Mr.
One question.
He says, I have one question.
You came here and one of your first, let me get it.
Objection, Your Honor, improper.
I haven't asked you.
It's not improper. She opened the door.
I'm sorry, I haven't asked it.
She doesn't want to hear the answer, but she opened the door.
Yet.
Ask your question.
When you first took the stand, you said, I feel threatened.
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Anything else in this one?
And the prosecutor thinks she's going to do a good job on redirect, and basically she just steps in it even more because the lady's like, yeah, you put me in an ankle monitor, you arrest me, you force me to be here. You just don't want to get into that argument. But let's listen to it because it is interesting.
Ms. Holmes, you said you feel threatened, of course. Okay. Did you fail to appear for numerous court appearances?
No, I never served me, lied.
Okay.
Lied to the court.
And with regards to, did you work in Redding, California?
Yes, I
By the way, the witness just said you lied to the court. Now, the witness can be wrong, okay? But they are testifying. The witness is testifying. What the witness says is evidence. The lawyers don't testify. What the lawyers say is not evidence. So if you think there's a double standard, I understand, but there is a difference. The witness and the lawyer are there for different purposes. And the lawyer is about to say, that's a false statement. And that is totally inappropriate because now you are testifying. You are telling the jury something that you want them to believe. That is not what lawyers are supposed to do while they're asking questions.
Empirical rules.
And so that was a location you were at.
that's why I was traveling. Yes.
Okay. And in terms of the prosecution, you have been served on various occasions to testify.
You served me a subpoena on November to be the next 15 hours in California, 10 hours away. It wasn't even served correctly.
And prior to that, you were served with a subpoena in
Never.
February of 2019.
You never served me. I know you served to a location. I didn't do that anymore.
Do you recall coming to the courthouse in February of 2019?
Objection beyond the scope.
Excuse me.
Anything about the courthouse.
Excuse me. I'm sorry, Mark.
The state's basically ruined my life.
And in terms of your feelings and ill will towards the state and myself,
I just feel like you lock up innocent people.
and does that influence your testimony today?
It's not influencing my testimony.
Have
No,
you-
I'm telling you.
Have you- that's not-
I'm
that's
very
not-
serious.
Excuse me, hold on. Only one of you can talk at a time. You ask the question, counsel, you answer it, and when you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
Yes, sir. So the my question was non-responsive on that one.
Ask your question.
So, Ms. Holmes, in terms of the court order that was issued,
Yes.
you're aware that that was found to be valid?
No, I'm not with that at all.
It's
Okay,
so
you hired an attorney?
it just doesn't work to get into these arguments with lay witnesses. The court order was granted. You're aware of that, right? It's like, just don't get into those arguments. But now she tries to say, oh, you hired a lawyer, so you must be bad, which always bothers me. But here's where the state steps in it again.
To go and represent you at the Fourth District Court of Appeals?
He had to hire an attorney to try to get in this far.
And that's a false statement.
Objection.
Excuse me. Counsel, you're not testifying.
I agree with
You
that.
excuse me, you asked the question, all right? That's it. You asked the question.
And so
Can I tell you what's never good? When the judge does this. Counsel, you are not testifying. You ask the questions. Because the witness said, you tried to get my lawyer disbarred or something snarky, which I get. She's a difficult witness. She's an adverse witness. I do not wish to be in the shoes of the prosecutor here. This is hard. Sometimes it is very hard. But you cannot let yourself be dragged down into these arguments to say, oh, that is not true, because you are not testifying and the judge was absolutely right to reprimand the attorney for that. It's not great. It's just not great.
And he moved for a mistrial, guys, in front of the jury. The jury heard him say mistrial. Apparently, the judge was like, "No, fuck a mistrial. We going." The judge like, "Fuck that. We ain't doing that shit. We ain't starting over. Let's go. Keep going. Keep going."